Cases before this said so. This is not in the material, so write this site down. This is on a remand from Ohio versus Robinette. And the state of Ohio, Ohio Supreme Court, rejected U.S. Supreme Court's holding it and went further than the U.S. Supreme Court even would have expected them to do, and rejected the Supreme Court of their state constitution. We first determined whether Robinette's stop and continued detention were justified. It's undisputed the officer was justified in stopping because he was speeding. That's always the objective basis. We find a nuisance instruction to Robinette to wait for the exit vehicle was justified because it was a traffic stop, MIMS. Once he was administered the warning for speeding, the reason for the stop ended. This is Ohio, not a bastion of liberality. However, Newsom continued to detain Robinette pursuant to a drug interdiction policy. The drug interdiction policy required the officer to ask persons detained during a traffic stop. This all had to have come out during cross. Well, what's the basis of this stop? What's the basis of continuing the stop? Why did you continue? Why'd you keep asking them questions? Well, we're trained to do so. Well, they all are. The example I used in the newspaper article, the cops admit they're trained on drug interdiction policy. It's a great opening. It's their own admission. You can put the newspaper article in against them. We know here that pursuant to Wren versus U.S., the officer's subjective intent for continuing the detention is irrelevant. And the police officer's objective justification, and these italics are all added in of mine, to continue the detention of a person stopped for a traffic violation for the purpose of searching the person's vehicle is not related to the purpose of the original stop. When continued detention is not based on any articulable facts giving rise to a suspicion, it should say a separate suspicion, of some illegal activity justifying an extension of the detention, continued detention to conduct the search constitutes an illegal seizure. And that's 11 years ago. Alaska, 7 weeks ago, in the materials, it doesn't have the updated site, but it came out last week, now Pacific 3rd, under the state constitution. They were afraid, and their own case says so, they're afraid that the U.S. Supreme Court, if they got this case under the Fourth Amendment, would say this is all valid. So they just decided it under the state constitution because it was obviously argued by defense counsel. We reject the notion that as long as the police officer's questions do not extend the expected temporal duration of a traffic stop, the legal nature of the stop remains unaltered. Even when an officer questions a motorist about potential crimes, seeks permission to search the motorist of the vehicle. As shown by the facts here, in the experience of other states, which they cited other cases, motorists who have been stopped for traffic offenses do not act from a position of psychological independence when they decide how to respond to officers' question to search. This is dealing with the fictions, what all the other courts have said. Alaska's not the first to do this, just the most recent. Because of the psychological pressures inherent in the stop, and often because of motorists' ignorance of their rights, large numbers of motorists, guilty and innocent alike, accede to these requests. Moreover, because traffic regulations are so numerous and detailed, most motorists will violate the regulations somehow. In the case here, it was because the license plate was dirty. That was the excuse. Well, it's Alaska. If the roads have been sanded or salted or whatever in the wintertime to make the vehicle capable of driving, the car's going to be dirty all winter. You won't be able to see the license plate. Because the violations of traffic regulations are so frequent, because motorists are stopped often exceed the police officer's request, the Fourth Amendment rules governing these stops create the risk that law enforcement officers will compromise the privacy of many citizens. So this court's recognizing the Fourth Amendment doesn't go far enough because what the cases will say. Fourth Amendment rules allow Alaska law enforcement officers to search dozens or even hundreds of people without any justification. For these reasons, we hold the state constitution grants greater rights. We jump down to the bottom. The officer conducting traffic stop was prohibited from requesting grounds permission to conduct a search that was unrelated to the basis of the stop and not otherwise supported. So any questions, this is Ohio on their constitution, said any questions beyond the purpose of the stop cannot be asked at all without some independent justification, which they have to articulate. They have to be prepared to come to court and articulate it. Now they'll come up with some post hoc bullshit about what they think it was, and then you can cross-examine them about why it doesn't show up in their reports or it's in the reports, but it's greatly expanded on by the time they testify. That's all with basic fodder of cross-examination. Once they figure it out, they'll realize they have to start writing the reports in a certain way. It'll take a little lag time before they pick up on it, but they will within about a year. Kansas holds that Mueller versus Mena does not permit a law enforcement officer to ask questions of a passenger. And they said that case is limited to search warrants, period. We don't have to go any further. Oregon, Lee would know, holds that asking a defendant for consent to search for weapons is outside the purpose of the stop. Therefore, the question itself is unlawful, and people will just fall into that trap and agree to allow the search to occur. In preparing for this, I just ran a search of traffic stop in title in law review articles. This was in the group of the first 10, and these aren't materials because I forgot to include that page. But just write down these citations. You can run them through Westlaw or Lexis just by typing the citation and get a document box from Ohio and Rutgers. And oops, this is in the wrong place. This one should be down here. Sorry. Macklin's police interrogation during traffic stops. No questions and answers. It's free on NACDL's website. Well, Faves is in the materials without the footnotes. And it's about, as it is about 40-some pages long. Illinois and Fordham. The Fordham article is particularly good from 2003. So I submit to you that Terry can be applied to all these because the stop is based on probable cause for a traffic offense, not for whatever it is they're asking questions for. So Terry, the question of, is the stop tied to the justification? The continuation of the stop tied to the justification that led to the initial stop? The answer is no. That's Terry at 19. So Terry will answer these questions. So go forth and apply Terry to a traffic stop. And most of the answers are there. Terry, probably next to Miranda, and next to Katz, probably the most cited case in our jurisprudence. The Fourth Amendment won't work in your case. Plead the state constitution too. If you're stuck in federal court, you obviously can't plead the state constitution. I know some lawyers who have, because I've seen the state suppression or federal suppression motions citing the state constitution, and I lament that they just citing it without even thinking. But impress upon the court reality. The person just can't drive off when the cop is standing there talking to them. The cops don't expect them to drive off. The people don't expect that they can drive off. They're stuck there until the cop turns around and walks back to his car and said, have a good day, or drive safely, or whatever. Until that cop turns around and walks away and doesn't say the one more question. Because some of them I've read where the cop actually turned on his heel, the court said, turned on his heel and walked away, and then turned around and came back. When they came back, they reinitiated another stop. They say you're free to go, but wait a minute, you're not free to go. So one stop ended, did another start? Is it a continuation of the same stop? You could argue that it's a second stop if you want to. And that second stop has no justification whatsoever. The good and bad cases are posted daily as soon as I get them. FourthAmendment.com. I haven't posted in 2 days because I've been here, but I got a little due to get caught up. I sometimes spend the weekend getting caught up. I don't even know what's in there yet. I haven't read them yet, but I'll work on some this afternoon. And whenever there's a bad case or a good case, it's in there. Because we need to know what they are. If there's a bad case in your jurisdiction, you need to know it. If there's a good case in another jurisdiction, you need to know it so you can cite it. Bad cases can transmute across state lines too.